order. Okay, we are good to go. I am Byron Tate, editor of the Pine Bluff Commercial, and this morning we have Therese Free and Mac Norton. They are running for a circuit judge position in this district. It covers Jefferson County and beyond, and that is a seat vacated by Judge Bill Benton, right? This is, we appreciate these two candidates for participating in this. This is kind of uncharted territory with COVID, so we were trying to get something out to so that readers could get a better idea who these candidates are. So thank you for that. If I want to just start out, I do have a list of questions, but I wanted to start out and just ask you guys to tell us about yourselves. The last question is, why will you make the better candidate? So you can hold that keep that powder dry for a bit, but just tell us about yourself, when you went to law school, and some of the high points of your career. And we'll go in alphabetical order with Ms. Free.
Yes, my name is Therese Free. I'm running for Circuit Judge in 3rd Division, which serves Jefferson and Lincoln County. And I grew up in Lincoln County, was born in Pine Bluff, grew up in Lincoln County, and have lived all over the state and have moved back to Pine Bluff for the second time 11 years ago. I'm very involved in my community in Star City and Pine Bluff area, both counties. I graduated from Gould High School, and gosh, what year? 1975, I believe. I went to college and got my undergraduate degree in UCA. Then I went back to law school after my children got a little older. I desired to go to law school, but put my family first and waited till they didn't want me to go to school any longer. So I went to law school at UALR and graduated and became licensed in 2001. And I've been practicing all over the state. Love the practice of law, have hung my own shingle as soon as I got licensed, and been practicing in a variety of areas. Oh, and I have 2 daughters and 5 grandchildren.
Okay. Thank you. Mr. Norton?
Thank you, Byron, for this opportunity to not only share with you, but also to share with whoever you want to present this to. But my name is Mac Norton. I am a candidate for Circuit Judge of Jefferson and Lincoln counties. It is Division 3. My background is I was born and raised in Pine Bluff, as I tell many people, and I was just basically sent off to be educated. I graduated from Pine Bluff High School in 1971, which quite frankly, the first year we had consolidation here in Pine Bluff, and all the high schools came together in the school district. I went on to Hendrix College at Conway, graduated in 1975 with a BA degree in business and economics, and also a double major so I could teach school if I wanted to. Decided to go to law school, had to take a bar exam, did well enough on it, and with my grade point to get into law school, I went to University of Arkansas Law School at Fayetteville, graduated in 1978, came back to Pine Bluff, practiced law, and thought in fact I was going to be on my own. And I went over and talked to Joe Holmes at the old National Building and rented an office. Started getting some equipment together, and then a friend of the family called me, E.W. Brockman, and they wanted me to come in with him. He said he had too much work to be done and couldn't get it all done on his own, and so that started a friendship and a relationship that lasted for quite a long time. Anyway, E.W. is my mentor. He's probably one of the finest men I've ever known. He was an outstanding lawyer. And so I learned a lot through him and with him. I have served as special judge in Jefferson County and Lincoln County in both the circuit court and district courts in the past when that was allowed. That's pretty much not allowed anymore, but it was in the past when we needed a judge and the sitting judge was not available. I'm past president of Jefferson County Bar Association. I'm a member of the Arkansas Bar Association. I've been a member of the CALS Pro Bono Referral Service since 1983, and that's where lawyers sign up to handle cases for indigent clients through the Central Arkansas Legal Services. I'm past president of 50 for the Future, which is a business organization here I was voted best of the best attorneys by the Pine Bluff Commercial in 2018 and 2019. I'm third generation Pine Bluffian, former chairperson of the Pine Bluff Parks and Recreation Commission. I've served for over 35 years on the Seabrook Family Christian Center Board of Directors and continue that position now. I'm a deacon at First Baptist Church. I'm involved in a group called Men's Bible Study. I lead the children's division of that. I've been married now for almost 40 years to Susan Condrey Norton. I have two grown children, Catherine and Ryan, and I'm an avid hunter and fisherman. And I think that just tells whoever's listening to this or reading this a little bit about me and my background.
Okay. So I put together some questions and transparency here. I was more interested in the candidates' answers than necessarily their spontaneity. So I sent the questions to them. They have had a chance to look at them. I tried to pick questions that judge candidates can answer. We can't ask, well, we can ask, but you all won't answer questions that relate to things that people might really want to know, like what do you think about the death penalty? But so let's just get started. My first question, we'll just take them in order. Technology is changing the way courts operate, such as electronic filing and online payment of fines and fees. What measures ensure fair and adequate judicial access to those citizens that don't have the technological capabilities or knowledge necessary? We'll stay with our alphabetical order for this one, and then we'll flip. So
Okay.
it's free if you want to go first.
Sure. Byron, we're very fortunate in Jefferson and Lincoln counties. Pro se clients can come into the clerk's office and the clerk will electronically file their pleadings. As you can imagine, having electronic filing has been wonderful time savers for attorneys, but it's just not feasible for the pro se clients. The attorneys had to initially take a little class in electronic filing. We also had to pay an initial fee to be able to electronically file, and that is not feasible for pro se clients to have to pay that initial fee just for one case, of course. And then, like you say, there are people who are not savvy in technology, so it would be very, very hard for them to do that. So we are fortunate in Jefferson and Lincoln County that the pro se clients can come in and they will file it for them. And as far as paying their costs, they can write a check or right there in the clerk's office. Whereas it's been great for the attorneys because we can pay with a credit card our initial cost for the filing.
Okay.
Mr. Norton?
Therese was spot on, Byron. That's exactly the way we do it now. Not all of the districts or divisions of court in the state of Arkansas have electronic filing, but there's a deadline. I think most will have it by the conclusion of this year. Jefferson and Lincoln counties both have electronic filing, and so that's the way it operates. The good part about it too is sometimes the pro se people, litigants, when they file, don't know to provide a copy to the other side, and so now automatically the system that sets all this up electronically, when something's filed, it automatically sends a copy to whoever the attorney or records are in that case, whether one or more, which is really good because it allows you to keep up with the case and you don't have to wait on the other side sending you a copy of whatever they filed. So that's been good for all of us. And but the pro se litigants and individuals that don't have the technology or capability are at a disadvantage. And that's why our judges, I hear them repeat it many times, encourage them to get an attorney, especially if it's a complicated situation. We also have something that's been operating now for several years. It's called Access to Justice, which is promoted by the Arkansas Supreme Court and Arkansas Bar Association, where the clerk's office actually has forms that can be obtained to assist pro se litigants in, I'm going to say, more of the routine matters like to modify child support, or to end child support. That's a problem because when the time comes to end the child support, it doesn't happen automatically. An order needs to be entered. And so, there's a system now set up to where, pro se litigants can do that at minimal cost. Now, there's, the clerk's office provides a form, but the clerk's office does not provide them with advice or information how they're to complete that. But most of these forms are basic, pretty simple forms that they can utilize in what I'm going to call the less complicated cases. Now, there are instances where they try to use them in complicated cases, and it just doesn't work. So, because actually it's something that they need an attorney for, but sometimes people just don't have the money, and so they're going to represent themselves, and that's just something that a judge has to be sensitive to whenever he has a pro se litigant in the courtroom, to make sure that the proceeding is fair, but also to make sure that the court doesn't step over the line and end up, providing advice or what might appear to be representation for that pro se litigant. So it's sometimes it can be a tough line to walk for the circuit judge when you have a pro se litigant in the courtroom.
Right. Okay. All right. So, Mr. Norton, this one goes to you first. Cases can last several months or longer. What can courts do to achieve effective case flow management?
Good question, Byron. Hard to implement because basically our judges, and I think it's been a good policy, they don't review the filings periodically to see if they need to set a hearing. Now, they do have a system set up to where if a case has not been prosecuted, it means there's been no action in that case for at least 1 year, they send out a notice and that the case will be dismissed unless action is taken to move it along. But our judges and most judges I've come in contact with pretty much let the attorneys or the litigants involved move the case along. And what happens is normally the judge will not schedule a hearing or a trial until one of the attorneys requests it. And normally that's done through the trial court assistant that the judge has to make sure that the court date that's selected is good for both attorneys and is far enough off that they can be prepared. One thing that Judge Jameson uses, which I intend to use, and in fact, Judge Jameson got it from Judge Dawson, and it's a pretrial report that he requires the attorneys to turn in generally 1 week before their trial to identify witnesses, exhibits, and that type of thing to make sure that attorneys are getting prepared for trial. And then in cases that are a little bit more involved or a little more complicated, I think it would be important to also do an actually pretrial conference where the attorneys come in and we go over the basics of the case, make sure everybody's ready to go, and make sure there's not something that's going to be of a complicated nature that might cause a continuance at the last minute. There could be a witness, it could be, any of a number of things that could occur, but that happens. Cases get continued, and usually they're continued for good cause. But that's just, kind of what we have to deal with. And then you just want to make sure that if it is continued, that you get it back on the docket as quickly as you can.
Okay. Ms. Free?
Yes, a judge is required to hear the cases promptly and efficiently while ensuring that the litigants do have an opportunity to be heard. Just as we've all experienced the COVID-19 in our daily lives, the courts have really been hit hard with the COVID-19 because they haven't been able to have like jury trials and that sort of thing. We have had some Zoom hearings in some of the cases, which has helped a lot, but whoever wins this election, there is going to be a huge backlog of cases to be heard in third division. Probably the trial court assistant and the court reporter is going to have to get with me and maybe work some longer hours just to get caught up, because it has to be caught up, and whatever it takes, it's going to have to be. Third division here is very, very time sensitive cases, such as the orders of protection. Those have to be prioritized. Temporary custody litigation, custody litigation for temporary hearings where there's emergency hearings for guardianships and emergency hearings and divorce regarding custody. There's lots of time-sensitive cases, including the civil commitment hearings. So whoever the judge is in third division, you have to really stay on top of things, and you have to really prioritize, and you have to hear cases. You can't let them get backlogged. I believe Mr. Norton was referring to Rule 41B of the Arkansas the rules of civil procedure. Whereas, like he said, if the case has not been heard and it's just lingering, then the judge sends out notices, and the litigants, even the pro se litigants, get a notice, and then they have the opportunity to come before the judge and show cause why it should not be dismissed voluntarily.
Okay. Okay. This one goes to you, Ms. Free. Circuit cases include criminal, civil, probate, domestic relations, and juvenile matters. What is your expertise with each? And I added that this judgeship pertains to matters other than criminal cases, so please focus on areas that you believe show your experience would best be used.
Yes. Well, in my last year of law school, there's a rule that allows third-year law students to practice law under a licensed attorney. So I practiced under a criminal defense attorney for that year. And then after, I was solo practitioner in criminal matters. I soon learned that my heart goes out to the family law cases, but I have practiced criminal law for several years. I have practiced in the juvenile court. I was juvenile prosecutor for the city of Pine Bluff in 6th Division, Jefferson County. I serve right now in a diversion program in juvenile court. I serve as the teen court judge. It's a little volunteer thing for the mentors and the children the students who participate in that program, and they decide the sanctions or the sentencing for first-time offenders, such as the disorderly conduct, shoplifting. That way, the minors, the juveniles who are first-time offenders in things like that, get to come before me and the teen court jurors rather than going before Judge Brown, who is our juvenile judge. Also in juvenile court, the dependency neglect cases where the parent, DHS takes the children away from parents. I represent families against DHS to help reunite the families. I've worked to reunite hundreds of families over the years in several counties in juvenile court. I've also done a lot of probate, guardianships, adoptions, and a lot of domestic relations. I have a private practice and hung out my own shingle, so to speak, as soon as I was licensed. So I've had a variety of cases over the last 19, 20 years. Okay. And I've also sat as special judge for in different areas, juvenile and domestic relations.
Okay. Thank you. Mr. Norton.
Byron, we talked about before previously about the cases Division III will have, but your question starts off with the various types of cases that are heard in circuit court. A circuit court judge has authority to hear any of those cases. Basically, anything from a capital murder case down to a mere change of names is what your broad authority and jurisdiction is. Now, Division III will generally not hear those cases, but whoever serves in Division III has to be prepared to take cases that are assigned to that judge because of another judge has recused for one reason or another. I don't anticipate there will be much of any kind of civil or criminal cases heard in Division III, but you got to be ready, like a car wreck. You got to be prepared to conduct a jury trial if this comes to that point. If it's a criminal case, you got to be prepared to do all necessary things in preparation for a criminal trial, which normally will be a jury trial there. But Division III operates pretty much under the old system of when we had probate and chancery judges. That was changed by amendment around 2000 to the Constitution. So Division III will be handling pretty much just family law cases. None of those cases allow for a jury to be heard. In fact, the courtroom for the division doesn't even have a jury box in it. So Division III hears, primarily divorce cases. And when you say divorce, it's not just divorce, it's also custody, support, if necessary, for children or spouse, and also deals with a division of property as well as responsibility for payment of debt. So it's a multi-issue case when you have a divorce. Paternity cases are heard where someone comes in to establish paternity, whether it's the mother or the father, Once paternity is established, then you've got to determine, visitation as well as support and custody. You have guardianship cases where you come in for either minors that need a guardian for one reason or another, or senior citizens, or an incapacitated person. That could be a senior citizen. It could be an incapacitated person by virtue of some type of physical or mental disability that needs a guardianship. You also then have estates where people have died with or without a will that have to be probated, so bills can be paid, property can be transferred. You have involuntary commitment proceedings where the prosecutor files a petition alleging that a person is homicidal, suicidal, or gravely disabled. If proof is presented that's clear and convincing that that is the case, then the court can order some type of assistance or help in a facility for that person for up to, but not to exceed 45 days. And as I think Therese mentioned, either in response to this or another question, you have emergency hearings. If someone files for a petition for basically an emergency guardianship or an emergency paternity or emergency custody, then if the court sees fit, can grant what's called an ex parte order. Just means based on the strength of that pleading, which normally has to be accompanied by an affidavit, that immediate action should be taken. If that happens, then the court is required then to conduct a hearing just as quickly as a docket will permit to give the other side an opportunity to be heard. So, the case, there's a lot goes on in Division 3, and in my experience from being practicing primarily in this area of the law, family law practice is pretty much what I do probably 75% of the time. And from my experience of being there and doing those at the courthouse, Division 3 and Division 4 stay quite busy with it. And so there's generally something going on in the courtroom or in the judge's office nearly all the time.
Okay. So, Mr. Norton, this question goes to you first. Attorneys negotiate agreements in many cases before being heard by the court. Describe the decision-making process in accepting or rejecting such agreements.
Well, I think first of all, the court should encourage that, not discourage it. The court should encourage settlement, but the court shouldn't step across the line and force settlements. And I've been in situations where, quite frankly, I've had judges that would, I'm not going to say force, but would exert a lot of pressure on the attorneys to resolve a case for one reason or another. And so I don't think that's good. I don't think the judge should cross the line in that regard. But I think the judge should encourage litigants, whether, most of the time it's going to be attorneys involved, but you could have pro se litigants, to try to settle the case if they can. Now, if the case is settled, then it's going to be reduced to writing or for the court to review, or they'll come in the courtroom and dictate it on a record so that an order can be entered after that. And the court should hear that or read it and make sure that what the parties are agreeing to makes sense. Is not simply an agreement for the sake of having an agreement and avoiding a trial when their agreement is going to cause nothing but problems. And I think the court should step in at that point and say, wait a minute, have y'all thought about this in this agreement? Because I think maybe you've overlooked it. Now, quite frankly, that doesn't happen very often. In the cases that I've settled and the cases I've seen with other attorneys have settled, most of the time the attorneys are on top of the case. They know what's good for their clients. And they resolve the case normally in a very fair and equitable manner because, it's a give and take process. You can't get everything you want. The other side didn't get everything they want, but you try to reach something that's fair and equitable between the parties. And quite frankly, that's one of the things that the court will make sure when it's put on the record that both parties acknowledge that it's fair and it's equitable and it's something they want to approve. And bottom line is, does the agreement make sense? Is it something that if the parties will act in good faith and due diligence, will it work? Now, you can have the best agreement in the world, but if you have someone that's intent on going their way and doing what they want and not being considerate of the full situation, then you're going to have problems. But for the most part, that doesn't happen, thank goodness. It's not been my experience anyway.
Okay, Ms. Free.
It's been my practice in my career that anytime we have a negotiated agreement, settlement agreement, property division, custody, whatever it might be, I have my client either sign it after it's reduced to writing, or the client goes with me to recite it to the judge. There's too many cases that I have had people come to me that had other attorneys before me where the negotiated settlement was negotiated without them, and that's not right. Every litigant has due process. There's certain provisions in the law that requires a judge to put in writing in an order any mitigating factors of why they deviated, such for like an equitable division of property and a property settlement agreement. They're required to write the reasons in the order, and also like a deviation from the family support chart in child support. So it's very important that every litigant has their day in court, but if they do get with their attorney or on their own decide to negotiate some kind of settlement agreement, then it needs to be reduced to writing and signed by the clients or recited on the record. And that's what I will require as a judge.
Okay. Ms. Free, this question goes to you first. How does the court balance the ideals of judicial economy and administration of justice when disposing cases?
Well, like I said before, I've said, first and foremost, every person who has a legal interest in a proceeding, in any legal proceeding, or their attorney has a right to be heard. Everyone should be afforded their day in court, I believe. The judges do have to be fair and equitable. They're responsible to see that the judicial process is carried through. The system's only fair, that they are fair and equitable. But every litigant has a right to due process. So you can't cut the corners on that, so to speak. You have to give the people their chance, their day in court. So you just have to balance the judicial economy and the administration of justice. That's all I can say. We're going to have to jump in there and get the cases heard because everyone deserves that.
Okay. Mr. Norton?
Byron, good question again. I have had the opportunity to actually practice that on many occasions, and let me give you examples. The court should combine cases when practical. The 3rd and 4th divisions of Circuit Court of Jefferson and Lincoln counties hear the same cases. They're basically, when it's filed, there's a random basically drawing that starts, and it'll go to Division 3, the next will go to Division 4, and back and forth. And so they should have theoretically the equal number of cases. But what happens is sometimes very, very similar cases, the same parties will have a case pending in Division 3 and another case pending in Division 4. And you won't, well, how would that happen? Well, let me give you an example. Let's say it's an order of protection case is filed. And let's say is the wife, mother comes in and gets an order of protection. And then shortly after the order of protection is filed, either she decides to also file for divorce, or say the other party, the husband, father, files for divorce, but it draws the other division. Well, in my opinion, when that happens, those cases should be combined for disposition. One judge should hear both the order of protection case as well as the divorce case, because they're going to have overlapping testimony, evidence, and now you have to understand that the domestic order of protection needs to be heard quickly, and the divorce case may not be able to heard quickly, but the same judge needs to hear them. We're not having that happen as often as it should in divisions 3 and 4. And I think once, whether it's I get elected to the position or Therese does, I think we need to work closely with Division 4. I've in fact visited with Judge Jameson about this, who's the presiding judge for Division 4, so that can happen. And if I'm understanding our dialogue correctly, I think he's in favor of that because it just makes sense to do that. And then you have paternity cases. Okay, you might have a paternity case that's filed alongside an order of protection case. And then sometimes you have child support enforcement unit is by law given at least 1 day, but I think the judges usually give them 2 days per month to hear child support enforcement cases. Well, believe it or not, there may be multiple cases involving the same father with multiple children, and the court's only hearing one of those cases. Well, when that situation arises, in my opinion, I think they need to be combined, and so that the court can look at the entire situation when making a decision just in that one support case. I've had fathers come in that have 3 and 4 child support enforcement cases going at the same time, but only one's being heard in court because that's the only one that's in dispute at the time. Well, the decision in that case, quite frankly, the decision as to how much money should be paid for support is going to impact the other cases. So to make it fair and equitable for everyone involved, the mothers, the kids, and the father, they probably need to be combined in many instances. Now, there are instances where it won't be necessary to combine them in every instance, but in most instances, those should be combined. So that you're hearing them, everyone's getting heard at the same time, and one won't feel like they're being mistreated and getting more or less or paying more or less than the others in the other cases. So there are opportunities that exist for judicial economy that they're going on right now that I don't think that we're really utilizing the opportunity to combine those. And if I'm elected, I intend to coordinate that with Judge Jameson so that we're in tandem and hopefully can move up both our dockets along by combining cases like that. It just makes sense. That goes back up to your other questions. And so, yeah, I think that the two divisions need to work closely. And I'm not trying to pick on anybody, but historically in the past, and I'm not talking about just Judge Jameson and Judge Benton, but even before them, the judges we had before them didn't always work as closely as they could have in keeping cases moving and combining cases for judicial economy. I'm going to make every effort to do that, though.
Okay. So this is our last question. Goes to you, Mr. Norton. What makes you the better candidate?
Well, I mean, we've talked about all these things up above. I think if I wanted to just narrow it down, it would be the 42 years experience I have in courtroom dealing with family law issues. From the beginning of the time I started practicing law in 1978 up to the current time, my primary practice has been in the family law area, which this court will hear those kinds of cases. Now, over time, I think my practice is probably increased more so in the family law area than it was at first. But and I would say roughly percentage-wise, I probably have 75 to 80% of my caseload and time exposed in these types of cases, family law issue cases that are heard in Division 3 and 4. And so only thing I can really tout is my 42 years experience. I'm a hard worker. Hard work doesn't bother me. I'll spend the time and take the time to make sure that the cases move quickly on the docket. I'm not going to make something go to trial before they're ready. I want to keep the docket moving. I want people to have their opportunity and day in court. But probably most important, I want to make sure when they do come to court and they leave that courtroom, they feel like they've got a fair shake. There was a level playing ground. They got to present their case. Now, within the bounds of law, because you can't let everyone just say what and do what they want to. But within the bounds of the law, procedurally, that they've had their day in court and can walk out of there and don't feel like that the court has, slighted them, or maybe there's an imbalance toward the other side. So I want people to have that experience in court. I can't guarantee that because everyone experiences things differently. And usually in this area of the law, when a decision's made and a person doesn't get the decision they made, then they want to blame it on the court. The court was bought off, court was unfair, or their lawyer didn't know what they were doing, because these are emotional. A lot of these cases, if they're heard in court, that means they're disputed. There's a lot of emotion involved in these cases when they're in the courtroom, and a judge has to be sensitive to that and consider that, but at the same time, don't let that emotion overtake the courtroom and get involved to the extent that it shouldn't. So I'm going to tout that 42 years that I've been in the courtroom handling all these kinds of cases, and of course still doing them right now.
Okay, thank you. Ms. Bree?
And Byron, I feel that my experience in my practice over the last 20 years has prepared me to be judge and preside over the type of cases that are heard in third division. The best interest of the child is paramount in all cases involving custody, whether it's divorce, custody, guardianship, or adoption. I've represented the best interest of children as an attorney ad litem over the past 20 years in many different counties in this state. In my career representing parents in dependency neglect cases, I've dealt with parents with mental illness, drug addiction, alcoholism in many different counties throughout the state. The compassion I have experienced while representing those parents will aid me in presiding over the civil commitment hearings. I plan to implement mandatory curriculum for co-parenting children when parents live in separate households, such as divorce, custody, and paternity. I have represented the children's best interest. I've represented the parents against DHS. I've represented parents in custody, divorce, adoptions, guardianships, probate. And I just feel that anything that has to do with children in a custody case, in a divorce case, in any kind of case that involves children, the family dynamics as seen through the eyes of those children is the most important thing in the case. So if parents come through my court in a custody case or in a divorce case or in a paternity case where they're going to still have these children, but they're living in separate households, they're still a family. Broken families are still families, and they have to do what's best for those children. And this curriculum will help them to learn how to help the children and make an adjustment to the new life that they're going to have in separate household with the parents. I'm very compassionate for all people. I live by the golden rule in every aspect of my life. I treat people the way I want to be treated. So pro se litigants that come through my courtroom will be treated just as the same as the people who have attorneys. I'm very adamant about that. I've seen that in courts throughout the state where that didn't happen, and it's wrong. I was also a young mother who got divorced with 2 preschoolers. I was very young, so I've not only sat in the chair of the attorney, but I've sat in the chair of a parent who was divorced and getting custody. So I think my experience, my compassion makes me perfect for this job. Thank you.
Thank you. Well, that's all the questions we've got. I want to thank our 2 candidates, Ms. Free, Mr. Norton, for joining us this morning. This is unusual circumstances. But I appreciate you playing along. We will try to get this out to the public as soon as possible, but I appreciate your participation, and best of luck to both of you.
Thank you, Byron.
Thanks for the opportunity, Byron. Have a great day.
Have a good day.